My name is Dan Bell, and I'm the author of Legal Process Design, Patent Invalidity and Infringement Analysis. I remember when I was new as a patent lawyer, one of the litigators at my law firm came to me because I had a background in computer science and this patent was involved in that domain. He handed me a patent and he said, can you check and see if this patent is valid? And does it infringe this product? And I remember sitting there thinking, what does he want me to check? I was new on the job and I knew some basics, but I wasn't sure what he thought he wanted me to check. And does he want me to do a prior art search? Is he looking to see if the maintenance fees are paid? Has this expired? What is he asking me? Does he have a list of issues he wants me to check for? Does he have a methodology he uses that he wants me to follow? But as I say, I was new on the job, and I didn't want him to know how little I knew. And so my purpose of this, really it's a book, is to teach you a new way to organize your practice in a meaningful way that will help you make sure you're covering the main ideas when you're doing invalidity and infringement analysis. And it's being structured, I call it legal process design. It's the intelligent orchestration of resources to produce well-defined, high-quality deliverables according to repeatable, trainable, measurable, and scalable processes. As you'll see in the book in a few moments, we'll break this book down into 3 courses, and each of those courses has steps or processes that you perform with steps. And the orchestration of resources is defining which parties that are performing the process, at what skill levels are performing which steps, and what order those steps are done in, what issues they're looking for, how are they going to comment on those issues when they find them, and how are you as the supervisor going to verify that what steps were done or not, and how do you do this in a trainable way so that as the process becomes accepted and is used more, and people vet the process and make sure it's not missing things and add things, how do you organize all that in a way that so when you bring in someone new, whether it's an administrative party or a lawyer, maybe an expert or engineer that's performing their part of the process, how do you bring someone in to do their part of the process that feels like they're getting a running start and it's not reinventing the wheel, and how do you organize all that in a way so you feel like you're doing this once or twice and getting this done well, and you have a package, if you will, that someone can follow, and put all this in a trainable way and scalable. So that's really what this book is about. And what's interesting about it is it's discussing patent law, and 2 of these processes, of course, are quite important in this domain and are used quite often. And so it'll covers both the law and the process to do this. And so in the midst of learning this new methodology, you'll be looking at an actual process, updating yourself on the law, learning how to do these things. And that's the purpose of this book. And it's as you'll see, there's chapters that cover basic information in the book, and we kind of breeze over those chapters in this because these videos are organized for CLE, and so they're focused at mid-level or above lawyer, even in terms of updating their knowledge, and so, but the book is a resource available to you since you've taken this course. And so if you're new, it's intended to be directed to you, and also if you're experienced, it's also intended to keep you updated, and the book will be updated from time to time along with these online CLE videos. So from there, let's move forward. My name is Daniel H. Bell. I'm a U.S. patent lawyer, and I'm a member of the U.S. Patent Trademark Office, a member of the bar there, also the Washington State Bar and the Oregon Bar. I have an undergraduate degree in computer science from Arizona State University, along with a Juris Doctor from Arizona State University. Upon graduating from law school, I joined Clark with Sparkman in Portland, Oregon in 2000 because they had a robust patent prosecution and patent litigation practice, and they were working for the largest software maker in the world, which aligned with my undergraduate degree, and also that this manufacturer is involved in all sorts of technologies, and I knew that technologically they would keep me interested. Clark has some very smart people that are very good at what they do, and so I began my practice there. In about 2007, I received a call from a headhunter who was working for that largest software maker, and was looking for a lawyer to teach a team of engineers in India about patent law and practice. And the team was doing primarily prior art search for the company, and they wanted to increase their sophistication levels to include invalidity, infringement, and other processes that the in-house lawyers wanted to be able to utilize this team for. When I joined, there were about 20 engineers. That team grew to about 45 engineers while I was there for just under 4 years. And indeed, the team did increase the processes it was performing for the lawyers at the software manufacturer. I left India in 2010 and began developing an online patent process curriculum following this legal process design methodology that I'll be talking about. And I was working primarily for the same company and engineers in India. I just was no longer in India. I also began offering offshore consulting services for companies that were looking at ways to reduce their patent process costs by integrating offshore and onshore resources. In 2015, I began developing a patent law only continuing legal education curriculum, and using these legal process design methodologies and teaching patent law and practice to lawyers on the webpage PatentLawyerCLE.com, and with the intention of creating efficiencies in patent practice and legal updates for CLE credits, and helping lawyers transition either from prosecution to litigation or from litigation to prosecution, among other services and CLEs that will be offered. So who is this set of online CLE videos targeted at? It's targeted at a creative lawyer who is proactive about saving their clients money rather than a more traditional lawyer who maybe just follows the mainstream. And so that's kind of who I envision being interested in these materials. It's lawyers interested in legal process design, which we've talked about and will continue to. Lawyers interested in CLE for law, practice, and ethics. And lawyers particularly interested, with respect to this book, in invalidity and infringement analysis. And other topics as we provide CLE credits for those will come up. And also supervisory lawyers interested in investigating process design methodologies or using these as training materials for scaling their capabilities, whether inside counsel or outside counsel. And one of the things I noticed about CLE is I'm a patent lawyer. Why do I care about bankruptcy or family law? I really don't know enough about bankruptcy law, family law, all these other areas that you see on CLE web pages. They're interesting. I think it's interesting to understand the various areas of law, and there's sexy areas of laws that come and go, and become of interest at any given time, and it's fun to have availability to that. But for me, this is very practical. I wanted practical training materials that were relevant to my job, where I could help my clients. The truth is, if I get a client or friend or family that has trouble with these other issues, I just need to know enough to focus them in the direction of a lawyer that practices in that area. And so I kind of felt like I was wasting my time on some of these CLE courses, and I wanted to focus these materials on things you can use in your practice. As you may suspect, working in India with in-house counsel from Fortune 500 companies around the world, I had the opportunity to meet some very creative and interesting people who were not only solving legal problems, but they were using their legal knowledge to help solve business problems, and always asking, is there another way to do this? Is there a better way to do this? Do we need to go to court? Is there a way we can design our business so that these problems don't come up in the first place? And so I would invite you to think about being a creative problem solver. Be proactive and creative. Don't just wait till problems come to your client's door, but think about the way they operate their business and whether you can avoid problems altogether or reduce problems greatly. And when you're designing these processes or helping to design the business model, try to save your clients money. Be conscious about where services are being utilized, who's performing what services, and whether or not the service is required at all. Because the ultimate goal, of course, is the duty to shareholders. Is the old way still the best way? I know when I was working in-house, or forgive me, when I was working at a law firm, it seemed as if there was this idea that the old way, no one said it, but there was this tendency to want to just stay with the past because it's lower risk. Look, we've been doing it this way for 30 years, for 50 years. But when you begin to meet some of the in-house counsel and see what they're doing, you'll realize that the old way might be lower risk in some cases, but not if it's so much more expensive and you're not evaluating risk versus reward. And so try to save your clients money and think about it. Is this old way still the best way? Let me give you some examples. We're all familiar with tax havens. Of course, companies often form offshore entities, whether it's they're formed in the Jersey Isles or somewhere in the Caribbean or Hong Kong. We're familiar with tax havens, of course, and the purpose of those is to save clients money and reduce liability from lawsuits and all sorts of things. Also think about patent havens. I mean, is your client running servers in the U.S.? A lot of the non-practicing entities are patenting mainly in the U.S. and Europe because they know that's where the businesses with the deep pockets are. But do the servers need to be in the U.S.? Can they be in Canada or Mexico? Can they be offshore somewhere? It's not breaking a law to run part of your business in another part of the world, and yet there aren't patent claims in many of these domains. And so if the servers run fast enough, begin to think about the business design. Where are the servers? Where are things made? What about research and development, for example? In the U.S. now, there's trouble getting enough skilled talent into the U.S. There's not enough visas out there, and so ask yourself, do all of my R&D functions need to be in the U.S.? Maybe they should be where the talent is that I'm trying to hire. What about manufacturing? What are your costs to manufacture in the U.S. versus overseas? So these are obvious questions that all of us here talked about, and as lawyers, we have to begin to be able to think about what the risks are of these, and not just in the legal risk, but what are the costs associated with maintaining operations in one domain versus another. all of that brings us down to legal processes that eventually come up over time, and that's what this course is primarily about. Business design is just mentioned briefly now, because a lot of these processes you need to ask, do we need to be performing this process in the first place? Is there another way, by a business design, we can eliminate this risk altogether? But once you've gotten down to that question and you're designing a process, you have to begin to start thinking about the order of your process, and what order do you perform things in? For example, do you, with an invalidity analysis, do you if you're a if you're a lawyer working for a non-practicing entity, do you do an invalidity analysis right away on a patent? Maybe you do, or do you look for infringement first to see whether or not there's even revenue out there that's worth spending your client's your time, which is your client's money, on doing an invalidity analysis. So think about your processes, and even the steps within a process. Do I really need to be doing this now, or can I eliminate this step altogether? And also think about who is doing each step in a process. Is this step, gathering these documents, is that something a lawyer should be doing, or is that something you can have an admin do? In a search, now, is it better to have an engineer doing a search for prior art, or is it better to have a lawyer? It's going to depend on a number of factors, and many of which talent, ability, experience, and cost. And so we have to integrate all of this thinking into our processes as we develop them. And is there a better way? Again, I'll just finish. Is there a better way? Can we remove this risk completely from the start? And so, your job as a lawyer now isn't really just about the law. It's about figuring out how you can save your clients money, how you can be creative in designing their business globally in a way that reduces risks. And you want to think about what resources are being used and assigned to processes, and whether or not all of it needs to be done now. Could some of it be put off until later? Maybe those additional issues don't come up until later in the for example, the life cycle of an issue. And then finally, possibly, if you move something earlier in a process, do you eliminate the possibility that an even bigger problem is solved later? So all of these things have to be you have to think about, and so begin to think methodically about your processes. It's not just an art; it also involves cost. It involves venue or location, and it involves what the biggest risks are. And so think about all those things. So what is legal process design? Maybe it would help if we look at what the more traditional model of lawyering is. Many call it the apprenticeship model. A experienced lawyer hires a few or new lawyers to come in, and they teach those lawyers what to do almost on a daily basis. Do this, bring that back to me. Next, do this, bring that back to me, we'll discuss it, almost in a recursive model. As you know, in law school, many professors still use the Socratic method, which is you're teaching yourself, really. You're reading the case yourself, and the professor in class doesn't stand at the front and tell you what the case is about, but instead he picks people at random and asks you questions, as you know. And he tries to draw what the case means out of his students. And so in some ways, I suppose, the leading questions directs the class in the direction of the interpretation of that case the professor is looking for. But in the end, very few professors that I experienced would summarize the case in the last 2 minutes of class. In fact, many wouldn't ever do much summary of the law, and so you had to read the cases yourself. You had to brief them, create outlines, and be prepared to take the final examination, which might be the only thing graded in the course. And so this methodology, I think, found its way into law firms, where they tell you do this, and you go find out how to do it, what it is, what it looks like. Maybe you could talk the partner out of an example of one they'd done if you're lucky. I had a few projects assigned to me where I didn't even have an example of what one would look like when it's done. I was just going a little at a time, saying, well, how's this look? Oh, no, move this over here. And I even had gone into the files and looked for examples and was unable to find any. So it reminds me of a story when I first joined the law firm, and I was on the elevator with a partner, and I asked him about, do we have some sort of methodical training program he used that we use here at the firm, and he kind of chuckled a little and said, no, we use the most of the partners here use the pony model. And the pony model, what's that? He said, well, you take a new lawyer and you put them in a room with horse crap piled up over their head, and you come back a few days or a few weeks later, and if the lawyer's sitting surrounded by crap crying, you probably don't have someone who's going to make a good lawyer. But if they're shoveling the crap as fast as they can and they have a big smile on their face, then you might have a good lawyer on your hands, or somebody that's crazy, so you have to ask them, why are you smiling and shoveling so fast? And if the new lawyer says, with all this horse crap, there must be a pony somewhere, then you've got a good lawyer. And so with that in mind, it doesn't seem like the apprenticeship model is scalable. And that, I think, is what, when I ended up going to India and suddenly I didn't have 2 or 3 people in front of me that were starting new that I was trying to teach, but I had 20 engineers sitting in front of me, and I had lawyers that were expecting me to deliver work product to them that they could, if you will, review and make decisions about. And so I knew I was in trouble, and that's where a lot of these ideas came from. I had the fortune of working with a few very smart business people there in India who explained to me what happens often when companies, if you will, migrate part of their business processes to India, and how outsourcing and offshoring works, and that's where a lot of these design methodologies come from. And so what is legal process design? Really, it's an analysis of what you need to get done and how much time you have and who you are going to be able to use to perform that task, and coming up with a process that you can assign to these people and teach them. And so instead of maybe a less defined situation, you're going in with more definite. You're going in with whether it's lawyers or engineers or admins that you can use to perform this process, what steps need to be performed in order to get this deliverable completed, gathering documents, filling in fields, spotting issues, and what legal issues are you going to spot in this process? The law, in patent law in particular, and I'm sure in all domains, is quite complicated. And it literally takes you a life of study to understand patent law. And so if you're taking in a new lawyer or a new team of lawyers and admins and engineers, and you're expecting to teach them patent law in 6 weeks so they can perform a process, you're going to be, I think, overburdened. And so what you need to do is figure out what are the processes that they need to know to do this particular deliverable. And even some further analysis than that. What are the most likely processes to come up over a set of 20 or 30 files? And then how do you outline those processes and teach them in such a way that they can understand them not only theoretically, but be able to spot them in a file? And create step-by-steps that they need to take, create sample deliverables and templates that they use, and with showing fields completed and a discussion of what that field means, why it's important to the lawyer, and where they find that information. And then You need to have a project plan with a beginning, middle, and an end, and check-in dates, timelines. You need quality metrics so that you can measure when someone's doing well and when they're not. So you can use the projects that don't go so well, or deliverables that don't go so well, to push that back into your training materials, and so that you're actually teaching everyone in the group when one person in the group makes a mistake. And you need sample comments. I mean, a lot of what we do as lawyers really is just a description of something that bothers us, and it may be a few paragraphs or it may be a few sentences, and someone new is not going to have a lot of confidence to make these sort of issue spotting comments. So you use sample comments, and once they're experienced, they can be a little more creative. But then you want to have reading and testing materials. You want to have, whether it's case law or the MPEPs or the CFRs, you want to be able to teach these materials that they're going to have to spot and show examples. And then once you've tested them and they've met what initial testing criteria that you've set, then you run the process and you score the deliverables, and you create a continuous learning environment where the information that they have learned, when one person has learned it, it's pushed back to the entire group, it's pushed into the teaching materials, it's pushed into the quality metrics, and everybody begins to understand what one of these should look like, and when it's done right and when it's done wrong. And of course, you have to continually read the law, you have to update the checklists, you have to push all that back into the materials and teach them how to make those new distinctions based on the court's decision. And of course, all of this has to be done in a way that doesn't completely interrupt the work they're doing on a daily basis, so you have to be clever in how you accomplish these things. When I first got to India, I was teaching a process that was basically an analysis of prior art references that the examiner had cited against an application, and the engineer would go through those rejections one element at a time and indicate whether they thought the examiner was correct, or more specifically, only those in which the examiner was incorrect was any comment made. And of course, those were sent back to the lawyers that were, if you will, prosecuting those cases. And so that was that was what we were doing right out of the gate. Of course, I was teaching them how to form these in arguments, so that the lawyer receiving the deliverable could plug these into a office action response if they so chose, and many of them did begin to use those as written in their responses. Shortly after that, in about I think it was late 2007, there was a prior art search done on a patent that had been delivered to this software manufacturer, and one of the engineers had done a search and had missed a date on whether or not something was prior art, and that upset the client quite a bit. So I began to focus on invalidity analysis and what what issues, including priority law, would invalidate a patent. And I came up with a set of issues just naturally from my own experience in the domain, and by reading case law and Chisholm and whatnot, I came up with a set of issues. And about 8 months later, after I had spotted, a case came out, which you may remember. It was Aristocrat v. International Game, the Fed Circuit 543 F 3rd 657. Talked about improper revival not being of an abandoned patent application not being grounds for invalidating a patent, and went through some discussion about what elements could be used to invalidate a patent, and interpreted 35 U.S.C. 282, and basically came up with a set of issues that were almost exactly the set that I had assembled of how to invalidate a patent. And as we can see here on the slide, the subject matter eligibility, section 101, novelty, section 102, is the invention new, of course, which is a question you answer by doing a prior art search, and is it not obvious in light of the prior art, of course, which all of these issues can become quite complicated, as you know. And so it's not only which issues you pick, but which level of abstraction do you teach? At what level of abstraction, of understanding, are you going to try to bring into your process? Because, as you know, almost any of these issues you could completely spend a year on just studying the case law and the little tiny nuances. So there is an abstraction question in all of these too. Also 112, written description and enablement. We didn't study much about best mode because it's kind of something you can't get into the mind of what the inventor's best mode was when you're just doing research online about what's prior art, unless you can find something that author published themselves. Forgive me, that inventor published themselves saying what their best mode was. You can't really, so it wasn't a topic that we spent a lot of time on, but we touched on it. And then, of course, section 112B, indefiniteness, is the claim language definite? And interesting, this is, these areas is, with respect to invalidity, these are, this is where the case law is, primarily developed in litigation. This is the issues that lawyers are looking to invalidate a patent based on. Of course, down below we see unenforceability, inequitable conduct, although not as popular recently because of some changes, for example, Theracense. But also patent expiration, maintenance fees, and ownership are issues that come up. These are issues lawyers like to focus on because they will kill the patent, and it's not an issue. For example, if you have, I suppose this is kind of an ownership issue, or maybe not ownership, but inventorship. If you have an inventor not listed on a patent, and you're able to figure that out through depositions or whatever, it may not kill the patent. It's just then you have to petition to have that change. So it's not as important to spot an issue like that. All it does is delay the inevitable. So and of course for the infringement issue, of course you have direct and indirect infringement and all of the sections of 271, inducement, contributory infringement, and what have you. And so these are, if you will, the main issues. But each of these, in some ways, has a whole host of sub-issues that you have to understand in order to answer, whatever issues come up. And then once you've identified these issues and the sub-issues that you want to cover, what do you use? I mean, do you go to case law? Do you use Chisholm? Do you use the MPEP? What source do you use to teach this? And as you know, Chisholm is, thousands of pages. And so even if you just focus on these issues, you're looking at an amount of knowledge at abstraction levels that are not going to be practical to teach in a process that you're going to try to run in 5 days or 7 days, say. And then you have the whole other issue of if you have a subset of issues that you're going to, if you will, catalog and teach and test to make sure they can spot, then there's other issues that are going to be in the file that they're not even going to know to look for. And so you have to, as a lawyer, you have to understand what it is that's in scope and what it is that's out of scope. And you are responsible for what's out of scope in that process. You or whoever you decide to be the backstop on this deliverable. And so that's the issue spotting part of this, is what issues are likely to come up and are going to be the most lethal if you spot them to an invalidity analysis and or infringement or non-infringement analysis. So the structure of the 3 courses are shown here on this slide, and that's the order we'll cover them in. This course is the priority law course, which is shown as 100 there, and it is the context from which the other two courses and processes spring, because it's the law that determines what is prior art and what is not prior art, what is an infringing embodiment, what is not an infringing embodiment, and what is a prior commercial use and what is a prior commercial use, which are the temporal aspects of priority law. And that's what's covered in this course. There's substantive or qualitative aspects to anticipation and obviousness, which are covered later. This is more to do with priority law, which we'll cover first. Has to do with what claim, what date is this claim entitled to priority based on an earlier filed application under, for example, 35 U.S.C. Section 120, because it's properly and adequately disclosed under 35 U.S.C. 112 paragraph A and properly claimed under 112B, for example. Also, is it entitled to an earlier foreign date or provisional date based on Section 119? Is it entitled to some priority based on Section 365 and what have you? That's what priority law is primarily concerned with. Also, in order to evidence what our thinking was, the priority law course has a couple different tables that are used to set shield and sword dates. A shield date is a date that a claim is entitled to shield back as far as so that it can avoid prior art all the way back to a certain date, and a date before that is legally prior art, and therefore if you can find a sword that is on that date or before it, it qualifies as prior art. And so these sword and shield tables are what we'll use to provide evidence of what our thinking is to supervisory lawyers or others that are working on the case with us, and still understand what our thinking is. Priority law also covers pre-AIA law and AIA law. And when do you use pre-AIA versus post? As you know, the AIA does not affect pre-existing applications, some of which are still in prosecution and will issue later. And we'll study when AIA is effective, and it's very important to understand that distinction, and because those issued patents and ones that are yet to issue under the pre-AIA will remain effective until they expire naturally or what have you. For example, in priority law, early claims are entitled to their earliest effective filing date. You can have two claims in the same application that have different search dates based on whether they have continuity of disclosure and co-pending with earlier filed applications and what have you. Foreign dates can be used for establishing a shield date, but as you know, under pre-IA 102E, you can't use a foreign filing date to bring in a reference for sword or prior art purposes. 102B dates for each claim, a foreign claim under pre-AIA law, again, it can't be used to set the 102B date 1 year period. These sorts of things. The Hilmer Doctrine, some PCT applications are not 102E dates, as we know. What is an inventive entity? These are all priority law subjects. And of course, what is changed under the AIA? More prior art against later filed applications in the same family. If they have a claim that that relies on subject matter first filed on or after the March 16th, 2013 date, they are treated under the AIA, and that includes an application that had a canceled claim that relied on subject matter filed on or after that critical date. These are transitional type applications, the USPTO calls them. So that's what priority law is about. Spec map, I'll talk a little process and law. I'll talk a little more briefly about it because it's another process. But the specification map is something you do to take the substantive language from the specification and place it adjacent to the claim language in a specification map or chart is often called, to verify whether or not that language had 112A support. And then sometimes if you have earlier filed application adjacent to the present application, if there's an earlier filed application, you verify whether there's support in earlier family members by pasting that support language adjacent to the column where the of the existing application. Rule 56 comes up in spec map. I mean, are there family members that had references cited in them that were not cited in this case? Just if there's a highly relevant one, that's useful to the lawyer going in for a deposition if he's trying to establish knowledge or intent about the prior art. And prosecution history estoppel of what statements were made in the that can be used to limit the claim construction, claim definiteness, claim continued disclosure, subject matter eligibility. These are all functions that and issues that we talk about in the spec map process, along with providing templates, comments, sample deliverables, quality metrics, and law updates. The reference chart process, as we can see here on the slide, that has to do with the difference between explicit anticipation versus anticipation by inherency. Also, you know, more about the AIA 102A2 references coming in were not allowed under on pre-AIA 102E because a foreign filing date is now a prior foreign filing date can come in as prior art now. And also obviousness. These and other deliverables or other issues are disclosed in or discussed in the reference chart process, along with templates and comments and sample deliverables, quality metrics, and law updates. And then the infringement process and law, templates, comments, sample deliverables, quality metrics, law updates, you know, and then of course the checklists and process. Direct infringement under 271A, you got doctrine of equivalence under case law. Indirect infringement, 271B, C, etc. Vicarious liability and inducement, contributory inducement, product made by patented process, exporting components to avoid infringement. All of these issues and more are covered in these various topics that we see listed here, and they're broken into these areas. Now, we spoke earlier about not performing certain processes. This book will contain all of this information. We're only going to discuss priority law in this part of it, but as I mentioned, sometimes you don't perform certain things. For example, if you're just looking at a client wants to acquire some patents, they want to know whether or not those patents are infringed by any commercial embodiments, and so they want you to go do a infringement analysis to look for commercial embodiments that are infringing certain claims. Maybe they want to buy those claims and they want to know if they have any commercial value. If you establish that those claims are likely relevant to some commercial embodiment and may be used to create revenue or licensing fees, then they may have you go back and do an invalidity analysis. So the order is different depending on whether or not you find relevant information, and sometimes things are just not performed at all. So it just depends on the context. But this is important because the order of these take you through teaching you the law behind all of the processes, which is priority law, and then it takes you through invalidity analysis and then infringement. And so you'll know how to do all this. You'll see the processes and the documents to do all of this. But you have to be thoughtful about when and where to use things. So the traditional view of the context of these two processes, invalidity and infringement analysis, is in preparation for trial. But the truth is that very few cases actually make it to trial, and or result in a complaint being filed in federal court. It's a low percentage of cases. Even fewer cases make it past a Markman hearing if a case is filed, and many cases settle in the weeks before trial. So most of the knowledge is just preparing to negotiate for a better deal. It's most of the data and information you're gathering and the arguments that and the issues you're spotting are merely to put your client in a better posture, often for just a negotiation meeting of one kind or another, whether it be a licensing meeting, acquisition of a group of patents and that sort of thing, or who knows, security for if you're borrowing money based on a patent portfolio, or you're working for the bank that's lending money based on a patent portfolio. So, of course, the traditional business context folklore is that this is all about litigation, and often or litigation leading up, litigation support, and but that really just isn't what happens most of the time. And indeed, often it's not even on the horizon. For example, if with a freedom to operate study, the reason you're doing that is your client's about to put out a new product or service, and they want to know what the risk is of infringing someone else's patents. In some domains, like the computer domain, there's so many patents out there that it's almost impossible to do anything anymore without infringing something, and quite frankly, it's often something you didn't even know you were about to infringe. It's just so many patents out there. So freedom to operate is another context that you operate in, that where you run these processes. You're out searching to see if your proposed design is going to infringe anybody's patents, and you want to acquire those patents or invalidate them or neutralize them or design around them. And that's why you're doing a freedom to operate study of the patent domain in a given technology space, so that you can determine whether or not you would infringe anyone, and what to do about it, whether it's design around or otherwise. Due diligence, often you're doing invalidity analysis and infringement analysis for due diligence reasons. You're trying to figure out maybe for a merger or acquisition, two companies are courting each other to merge in some way, or acquisition, and they want to know what the other party's patent portfolio is, how is it valued in relation to theirs, whether it's posturing to get a higher value for your own company or to devalue another's. Today's marketplace, intellectual property plays a very important role in that, and so you're looking for those arguments that, if you will, belittle their portfolio and increase the value of yours. If you can show a large marketplace out there for monetizing your patents, or a future marketplace, your patents are worth more, especially if they're valid and in good shape in terms of their file histories. Portfolio acquisitions, you're doing due diligence. Is this patent any good? Are there issues with it? Are there problems with this group of patents? And as I mentioned, security positions for lenders, which is frankly a little bit rare, but there's some of that going on. And then you have monetization of patent portfolios, whether it's your own portfolio you're just using to generate income, or you're looking to acquire. Maybe you're working for a non-practicing entity and you want to go acquire patents to monetize, and you want to know what they're worth, or you already own the patents and you're just out monetizing them, and so you're doing infringement analysis. Of course, you're doing you're going to start with invalidity in that case, possibly. Once you've determined a patent's valid, you don't have to do that over and over again, but you then are out looking for embodiments that are infringing the claim language, and you're doing claim charts over and over again. Infringement claim charts in that case, they're also known as evidence of use. Cross-licensing, in that domain, that's where two companies are, if you will, posturing for litigation. One believes their patent portfolio is being infringed by the other, and they're looking for licensing fees, reasonable royalties, or even possibly an injunction. And so they'll go after a company with threats and a list of patents, and often if you can prove that you have claims and you can threaten them with an injunction, or you can, you know, at least, you know, fear of injunction is on the horizon, maybe is a better way to say it. Or counterclaims in terms of reasonable royalties. You put yourself in a better position for a cross-license rather than to have to just completely get out of a marketplace if they're infringing your patents, or you go buy some patents that they would infringe. So cross-licensing is another area where these processes are run. Non-practicing entities watch. That's where you're to the best of your abilities, you're trying to watch what patents that if you will, a non-practicing entity, or troll, they're often called, are developing in prosecution, or that have issued, and you're worried that they're going to come after you eventually. And you could do that in a number of ways, which we'll talk about, whether it's just watching who they're filing lawsuits against, on what technologies, what patents they've taken assignments of recently, if they are not playing games with assignment history, which some of them do. Again, that would be you're looking, that posture would be a non-infringement analysis. You're looking for design around reasons you're not infringing. You're preparing yourself to cross hairs with a non-practicing entity. Defensive review, that's where you're looking at your competitors or others' claim charts, and it's sort of like the non-practicing entity watch. You're watching what claims might read on your commercial implementations, and what sort of royalties they might expect to ask for if you don't, if you believe their patents are valid and infringed. And then of course you're thinking about designing around all the time, or what element of their claim language can you make changes with to so you're no longer practicing their invention. And then so defensive review and design around often go together in this context. And of course, offensive review, that's when you're monetizing your own patent portfolio and you're looking for infringers, whether you're a practicing or a non-practicing entity. And the concept of directed prosecution, that's where you have not only do you have claim sets that you're prosecuting, and maybe some of those are issued with the patent office, but you're also looking at your specifications that you have on file with early dates, and you're looking at what implementations arguably that your specification supports that you don't presently have a claim set on, and you're filing claim sets against competitors based on what's in your spec that you, at the time you filed the spec, maybe you didn't have claim sets to those parts of the specification in your application, but now that you've seen the direction the market's gone, maybe you're filing claim sets. And there's some limitations on your ability to direct prosecution, but that of course is another strategy that these processes are used in. So that gives you a good idea as a patent lawyer, that's giving advice to a client, the sorts of processes where these two, or the sorts of business contexts that these two processes arise under. Verification code. You must write this code down and enter it into the verification recorder to receive credit for listening to or viewing this hour. The verification code is YT100CVG. Again, YT100CVG. Now continue listening. Okay, now that you have begun to put together your design for priority law based on these issues, you're going to need sort of some introductory material to teach your newer people. So they're either newer, or maybe they're admins or engineers, and they may not be as familiar with the basics, the language that we use. And so the priority law course starts with the patent life cycle, and it has about a 20-page, 30-page discussion of basically ideas, vocabulary, and how a lawyer goes about receiving information that something may need to be patented, and goes through the motions of filing, having the patent filed, and having it prosecuted and issued. The chapter starts with a hypothetical lawyer that receives an email from a business manager about a certain invention, and the lawyer instructs the business manager, of course, to keep it secret to anyone outside the organization that's not under an NDA, should not know about the information, and that would preserve, of course, foreign rights. There's no, in most of the world, has strict secrecy, and so the invention should not be known outside the company until the patent application is on file. And then the lawyer does a preliminary search and verify that it doesn't seem to be anything on file presently for that type of invention, and then hands it off to an analyst to do a more thorough search, and then remembers law school, and that patent law is based on the Constitution of the United States. Article 1, Section 8, Congress shall have the power to promote the progress of science and useful arts, and by securing the limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so the lawyer remembers an example in college, and that about the right to exclude. A patent is a right to exclude others from using your invention. It's not a right to practice it yourself. And he remembers an example that the professor gave in class of a first inventor who invents a three-legged stool. It has 3 legs and a flat surface to sit on. And then another party reads that invention and realizes, boy, I'd like to lean back. So they, if you will, invent a back so that you can lean back on the 3-legged stool. And the lawyer remembers his professor talking about how the first inventor with the 3-legged stool can stop the second inventor from making a 3-legged stool with a back on it, because he invented a 3-legged stool with or without a back, and how the second inventor can exclude the first inventor from making a 3-legged stool with a back on it. And so it's really about the right to exclude others. Patent law is about the right to exclude others by injunction or charging reasonable royalties if they use your invention. He goes on to talk about that U.S. has recently switched to the first to file versus first to invent, and what that means. That under patent law before, it was the inventor, the first person to invent. If they could prove their day of invention, they had the earliest right to obtaining patent rights against another who invented at a later date. And how we moved to a model that the rest of the world has, which is, as you know, first to file, first inventor to file. And so now we've gone to that model. Of course, we've retained this grace period. If the inventor discloses anywhere, discloses within a year of their filing date, they're obtaining their American or U.S. patent rights. So that still remains. They still wouldn't be able to get foreign rights if they try to go with a foreign application. And then it goes through the types of applications. Provisional, non-provisional, continuations, divisionals, and then PCT applications, and what are the requirements for each, and that he, as he thinks all this through about how he's going to protect this invention for his company, and whether he's going to go for international rights. And all the purpose of this is to sort of just lay out how the lawyer thinks about the problems. And so the reader, if they're a lawyer that's new to this domain and they want to become a litigator or do research or what have you, they're beginning to learn the terminology. Or if they're an admin or an engineer, they would focus on this chapter more than maybe a lawyer would, or certainly more than a patent lawyer. And so this chapter really is in there. So you as a supervisory lawyer, when you design your process, you understand that they have to have a context for this information, and it's better to learn words in the context that they'll be used in, and where they derive their meaning. So that's what the intent is here with this chapter on the patent life cycle. It continues and talks about the difference between benefit of the filing date rights that arise under Section 120 versus a right to priority to a foreign application. which will allows you your invention date, but won't let you set your 102B date under the pre-AIA version of 102. And of course, this is much of this you'll actually know already, but it's important for you to know what's in this process, and so I'm just doing a slight review of it. It talks about co-pending. When you have a family of applications that are relying on each other, they need to be co-pending, and there has to be some inventorship in common and continued disclosure, and then the difference between the Patent Cooperation Treaty and the Paris Convention, and then what happens once they've selected a type of application and filed it in the U.S. It goes into prosecution then there's arguments and amendments made, and eventually it will issue, and there's maintenance fees, and then an assignment of that patent. Of course, patent rights they arise owned by the inventor, and then become by assignment. They're generally employers in their employment contracts require that inventors assign all of their inventions done on the job to the company, part of the consideration for their salary. And of course, then it goes into a little bit about enforcement. As you know, a patent can be must be enforced in federal court as opposed to state court, because it's arising under federal law, the U.S. Constitution. And so litigation patents proceed through district court, and then the Fed Circuit and the Supreme Court through the federal pathway, if you will, through the court system. And but also the International Trade Commission method that lawyers use to stop infringing imports from entering the U.S. It talks about that a little bit, and it talks about post-issuance procedures, re-examination, and whether it's inter partes or ex parte, and then the patent life. A little bit about how long a patent lasts, and where, and of course, all of this, the subject matter has links, if you will, back to the MPEP and case law, and so the curious reader can look at the statutory basis or the MPEP basis to understand where the support is for each of my assertions. And so in some respects there's case law in there and what have you also. And so then the chapter ends with the lawyer deciding which type of application he's going to file, and that he's going to file foreign, and he makes a decision of which countries he's going to file in foreign, and whether he's going to do it through the PCT or through a direct foreign filing. And it talks then about what his enforcement strategies might be, whether it's injunction or reasonable royalties, and that he can only do it in the domains where he does in fact obtain a patent. And so it kind of gives the reader a flavor of those types of decisions and thoughts a lawyer has in the creation of a patent in their portfolio for their company, and some of the decisions they have to make about delaying. For example, with a PCT, you can delay up to 30 months in most jurisdictions before you have to go with the national stage filing and whatnot. And of course, these terms are quite important to a prosecutor. In fact, the materials that I've developed for that purpose, which will be covered in another book, go into much more detail. In fact, that whole process is what the entire book's about, that runs into hundreds of pages. And that process, of course, goes into much more detail about the patent life cycle leading up to an issuance. And this book is more about strategies once a patent issued, and monetizing the patent and proving it's valid or not, depending on which side of the transaction you're in. And so with that, we'll now begin to look at in great detail, excruciating detail, what the difference is for the temporal aspects of, is this prior art or not, is this infringing or not, all based on 102. 103, is this invalid, and is this claim entitled to an earlier filing date in the family based on support and based on what statute, and is it a benefit claim or right of priority, and so we'll delve into that in the priority law course, which follows from here.